I was fresh out of law school, I threw myself into pro bono work like many new graduates do. I thought I knew the law, and I was really keen to share my wisdom. And so I started to volunteer at a legal advice clinic. And I remember one client who came in for her half-hour appointment looking for help with a divorce. She'd been married in the Middle East before traveling to Europe, where her husband beat her so badly she was hospitalized, before he fled, leaving her and her children to immigrate alone to Canada. After many years of scraping by to feed herself and her children, she had finally met someone new and wanted to remarry. How could she do this? She asked me in broken English. So I got some way down the path of explaining to her how to get marriage records from her war-ravaged home country, orders for substituted service against her long-vanished spouse, certified translations and affidavits, all to file a notice of claim, which was just the first step in the process. As the imaginary paperwork piled up between us, and she looked increasingly upset, I realized that although the law was on her side, there was no way she could enforce her legal rights. I stopped talking and took her case. But I began to think about legal process, all the rules, forms, applications, and procedures required on the road to someone's day in court. Process is like the bouncer at an exclusive nightclub. Process is boring, blunt, and often thuggish, but process decides who gets in, how long they'll have to wait, how much they'll pay, and what bits of paper they'll have to produce along the way. Process, though, is the key to the access to justice crisis, because process can either tear down barriers or build them up so high that only the wealthiest and most powerful in our society can scale them. 98% of US district civil court cases never get to trial. The number is the same in Canada. Now, as lawyers, we like to tell ourselves that these cases all settle on the courtroom steps. But we know from research this is a myth. Some people settle their cases, but just as many give up because they run out of time, money, or energy. Research also shows that the longer someone has a civil case in the justice system, the more their mental, physical, and financial well-being suffers. It's no wonder so many people forgo justice and cut their losses. So now, a decade after law school, I lead an access to justice initiative called the Civil Resolution Tribunal, which will let people solve their everyday legal problems online, where, when, and how they choose. I also teach administrative law. Now, every day, members of the public email me, telling me about their legal problems and excited to use this tribunal when it opens later this year. Their anticipation is palpable. But lawyers are more cautious. Lawyers are taught from the first day of law school to resist change. We teach them that. We teach them that precedent binds our entire justice system, and that what happened yesterday has to determine what happens tomorrow. We teach them to resist innovation or novel approaches to the law. And every first-year lawyer will tell you that when a judge calls your argument novel, this is not a compliment. But what we don't teach them is to consider whether precedent needs to bind process in the same way it binds principle. When we only teach, and so how do we reconcile what the public wants and what the legal profession is prepared to give them? Well, part of the problem is that as law professors teaching substantive courses, we don't talk about the bouncer, and we don't talk about the lineup outside the nightclub. We only talk about the people on the other side of the velvet ropes. When we only teach the words of the case law, treat the 2% of cases that go to trial as representative of our entire justice system. Yeah, we're teaching the law, but we're also committing massive selection bias. When we ignore the 98% of the public that never gets their day in court, by definition, we're presenting an elitist view of our legal system, and a fictionalized one, where everyone gets their day in court, and the product of that day in court is case law, which governs everyone. We're giving our students a two-dimensional view of a three-dimensional world. So what can we do about it? Well, let's talk about the bouncer. Let's talk about the lineup outside our justice system. Let's make process visible in our classrooms. Let's talk about who the parties are in the cases we teach. For example, Where do they come from? What is their socioeconomic background, their education, their ethnicity, their gender? Where do they live? How many of them represented themselves? Do they represent the broader group of people with these disputes? What processes did they have to undergo to get their day in court? And would other processes have worked instead? Which ones might have increased access and proportionality? And which ones would have reduced barriers like time, money, and geography? Would changing the process have affected the substantive outcome in the case? What would the body of law in your area look like if process removed all access barriers? What kinds of cases would be represented then? By asking ourselves these questions, we make process visible, and we teach our students to have a broader view of the justice system, one that recognizes the people to whom the justice system belongs and invites them into the classroom. This lets us build processes around the realities of people's lives, their jobs, their families, where and how they live, so that we can better serve them. And we can build these innovative processes. But first, we have to make the old ones visible, because you can't change what you can't see. This is something Nobel Prize-winning economist Daniel Kahneman talks about in a concept called what you see is all there is. The theory goes that when we're making decisions, we mainly consider known knowns, or information we've seen firsthand. We almost never consider known unknowns, or information we know exists and is relevant, but we haven't seen ourselves. So I really think that law students go to law school because they want to help people, and that they believe in fairness and justice. But when we teach law students to resist change simply out of habit, we undermine fairness and justice, and we hurt the people that we set out to help. We need to find a better way to serve our law students so that they can better serve the public. Now, not every law student is going to be a law reformer, but I believe that if we teach law differently, we can teach new lawyers, whether they're in corporate practice or whether they're frontline poverty advocates, to keep a corner of their mind open to the idea that we can deliver justice more fairly, more accessibly, and with the public at the center, even if it requires unprecedented change. Thank you.